Hello, from Gainesville, Florida, down in the swamp. I've been shadowing another case, the case of Mr. J.C. Trammell. I've been shadowing this case since May. Mr. Trammell has been in custody for over a year now, and he's only had a very limited amount of court appearances. The judge that was handling this case is from the 8th Circuit of Florida, Criminal Circuit, Criminal Felony Court. His name was Judge Davis. Judge Davis is now the senior judge, the chief judge over the 8th Circuit, which covers like 5 counties. Now, the judge that has the case now is Judge GROEB, and I have bought the court videos of this case. I don't concern myself with the crimes committed by these inmates. What I consider is once they contact me, okay, we work to get free phone calls here in Alachua County at our jail, and we outlawed the booking fee. So these people, they call me now from the Alachua County jail. Like I said, I don't concern myself with the case, whether they're guilty or innocent. That's not my affair. But are they getting due process? Are their rights being violated? And this is a case where it clearly shows some form of malicious prosecution. And the judge that had this case, Judge William Davis, he's now the head judge, so his cases got turned over. This man has been in the Alachua County Jail for a year in June, and it's now October, the end of it's Halloween. Happy Halloween. This case has left a very bad taste in my mouth. I've had a lot of correspondence through email to the court for this inmate, J.C. Trammell. It's left a real bad taste in my mouth, and I'm ready to vent.
Listen to the general every goddamn word. How many ways can you polish up a turd? And left, right, right, hell, broke loose. Hell, broke loose. Hell, broke loose. Oh, is it that the only ones responsible for making this mess? Got the sorry asses able to a goddamn desk, and hell broke loose. Hell broke loose. Yeah.
Now we're going to talk about some injustice here, some probable cause. We're going to talk about the state's case against him, but we're going to listen to the videos as it explains it after I read these emails to you. Now, this first email was sent on 4/26/2025. So January, February, March, April. Like I said, I've been shadowing this case for a while. J.C. Trammell, case numbers, blah, blah, blah. I have been in detention since July 11th, 2024. I've had a total of 3 defense attorneys assigned to my case to date. Attorney Hunt was informed, as well as Attorney Pierre, that I have not waived my right to a speedy trial. I had intelligently communicated to each. It was my demand to be tried within 175 days. I have been in confinement 287 days to present. I am 112 days after the date for a speedy trial. This is a violation of the 6th Amendment to the U.S. Constitution, as well as Article 1, Section 16 of the Florida Constitution, specifically citing Florida Rule of Criminal Procedure 3.191. These are the facts to the matter the court, the state, and defense have selectively acknowledged. March 27, 2025 motion, but my speedy trial had not been addressed to date. That was the nature/essence of my motion made. As a detainee and layperson, I cannot provide adequate information as to be exact. but that motion was made in context to my prior contact, starting with Attorney Hunt, invoking my right to a speedy trial at that time, citing Davis versus State, 2019, impinges on the July 8, 2024 contingent for this matter. At this time, I am insisting that if the court, state, and defense were to even bring my matter to trial immediately, this action shall be further infringement of my constitutional values and can only be remedied by dismissing all 4 cases against me. I am addressing the role of a Florida Criminal Circuit Court judge, and that judge should ensure my right to a speedy trial. That window of opportunity has well expired. Therefore, my case noted above dismissed. This was written for J.C. Trammell at his request via telephone conversations from the Alachua County Jail to create a record of this event for the sake of posterity. That's one email that I helped him with. Here's another. This is on May 2nd, 5/2/2025. I am at this time informing the court that I have not ever given consent and demand that my appearance before the court not be waived. I am demanding to be brought before the court to appear in person on my next court date. My understanding is May 5th. I could be wrong or misinformed, and so at any function of the court that hears the state's matter concerning me, I demand to be present. The Florida Rule of Criminal Procedure 3.180, Section A 3, states that the defendant shall be present unless waived in writing. This was written for J.C. Trammell at the request via telephone conversation from the Alachua County Jail to create a record of this event for the sake of posterity. This is another email that I sent for him on June 30th. Mr. Trammell has been in custody since June 11th, 2024. Mr. Trammell has had 3 attorneys to date. Mr. Trammell asked one of these attorneys nothing more than questions because of lacking the feeling of being informed and represented. Mr. Trammell was placed in the hole, for 30 days because this attorney would find fault in Mr. Trammell's demand to be informed and he adequately represented. As per Mr. Trammell, this attorney was replaced by another and then by another, which brings me here today. When a defendant is so obviously inadequately represented, shows the facts, makes the motions for a hearing to all concerned, and nothing occurs. The 180-day rule is the second most replicated nonconformance in the judicial purview. This was true to many, and all defendants that I have readily observed. That's me talking. These observations are the consistently constant that defendants that in this instance, Mr. Trammell wrote to court to include Judge Davis's court, praying for the right to a speedy trial. In fact, when the defendant wrote to the court, there was no response. The best of an inmate's ability to make a motion in absence of adequate legal counsel, the essence of why the represented defendant is on their own making these demands. Clearly and concisely, I have communicated to this court that I went to Mr. Trammell's attorney's office June 17th, approximately 16:20 hours, with Mr. Trammell via a jailhouse phone call, connected with him, his present attorney, and for factual reasons, Mr. Trammell now needs a 4th attorney due to what was revealed. There needs to be no speculation as to the events that occurred. That does not need to be disputed, as I am most confident his attorney will not object, as he is most busy. That's me quoting him. Attorney's words quoted. I do not consider this to be a situational or at the exact moment dependent response by the attorney after the context, the conversation, and multiple clues/details. That was the takeaway through one-to-one engagement that dispels the belief that Mr. Trammell is effectively assisted by counsel. I do not believe that I am wrong in asking if Mr. Trammell would not even be here now if he was properly represented and his right to a speedy trial adhered to. ? Obviously, Mr. Trammell has reacted to his lack of counsel by notifying the court of such shortcomings of representation. Obviously, the court does not take stock in any of the above because this is the court allowing these events, such as a myriad of misuse of case managements, lack of continuity, denial of due process, ineffective assistance of counsel, expiration of speedy trial time, and now a new motion for counsel. There is an argument that the state might not even have probable cause to obtain conviction as per Mr. Trammell. Just as an observer to compare and contrast that these aforementioned subjects don't seem to matter to the 8th Judicial. The 8th Judicial doctrine is clearly stated in the actions of the finalization of the work. Performed 6,000 pleas negotiated, 500 trials. The main takeaway from the debacle is that I must take action and make a complaint to seek redress of grievance. I am asking, as if in the format of a records request to be taken, what agency or institution outside the 8th Judicial is to where such a complaint would be directed concerning these matters? ? I believe that only the 8th Judicial would know the answers that I seek. Please include some example of prior complaints involving the 8th Judicial, or as to where these examples would be found, so I can formulate my complaint, so it will be properly received. This information can be sent to bluesteelfoilrequest@gmail.com. That's another email that I sent. Stacy Scott, the public defender, because I shotgun mail everybody. Mr. Trammell is represented by a private attorney, Stephen Bernstein, not our office. She's the elected official public defender. He has not been represented by us since August of 2024. That was the first attorney, Attorney Hunt. The one that put him in the hole for 30 days, just because he was asking her to help him. Okay, that's a corner. These are court videos. Okay, so after a while, JC got a new attorney, right? Bernstein, finally. Bernstein didn't do shit for the man. And so he wouldn't even go see him. So I went to Bernstein's office like 10 times. And finally I got up with him. And I knocked on the door. He said, come in. So I started talking to him. I said, I got JC Trammell, one of your clients, in tow right here. You speak to him. He's been trying to talk to you for months. And so I handed him the phone. And the conversation wasn't good. Now, after JC Trammell, you're going to see all this in the video. After JC Trammell put the complaint in on him because the attorney shot him a line of shit at that time, at that phone call, he put in a bar complaint on him. Then the attorney went to court. They brought JC to court. He hadn't been to court in appearance in over a year, but his attorney heard his case like 7 times. They were all case managements. I'll read them off to you. I know this is kind of boring, and this is a record that I'm putting out there. That's why I'm doing this, so I can send links with these complaints. Okay. This was for his new attorney. But see, the new attorney Bernstein was a conflict of interest. You'll hear that. So they passed the case to Bernstein's partner, Michael Rupert, which is a conflict of interest because same firm. Anyway, I wrote some kind of you'll hear what this is. This is like I'm here to introduce Mr. J.C. Trammell. The reason of such an introduction is for Mr. Trammell to make an easy transition to a new defense counsel. Mr. Trammell has only been to court one time prior to include being confined over the period of 1 year. Mr. Trammell possesses some baggage to this point via the situations that he has been exposed to. This is to be expected. These experiences are such that common sense explains the facts of actions and that to which he feels as if he has been denied due process. The first attorney, Deborah Hunt, would not contest probable cause. He wanted, like a probable cause hearing, a motion to see the state's evidence, to have it out there instead of it being secretive. Now, he has never received a full counting of the discovery. All right. At Mr. Trammell's urging, she would not exercise her time and advice, which is her attorney, Deborah Hunt's stock in trade. Deborah Hunt responded that Judge Davis only wanted to see Mr. Trammell when signing a plea of guilty. That's what the judge told the attorney. Deborah Hunt, caused by reporting Mr. Trammell to jail staff, he suffered time in the hole, solitary confinement. Deborah Hunt departed as Mr. Trammell's defense at her discretion, appointed attorney Evans Pierre Antoine, and had no functionality except to honor the Judge Davis's directive, and at Mr. Trammell's urging, still refused to provide effective assistance of counsel. Upon Attorney Antoine's point of selective exit, there was the appointment of Attorney Bernstein. Attorney Bernstein, at approximately Mr. Trammell's point of 1 year of detention, was unreachable, unapproachable, and made no attempt to contact Mr. Trammell at all. These attorneys leave these clients sitting in jail for ever, unless somebody like me gets in, or some of their family or somebody on the outside, hounds them and gets them the attention that they deserve. Mr. Trammell requested me to make contact with Attorney Bernstein on his behalf. I did so via a jailhouse phone call. Upon this moment, Mr. Trammell received Attorney Bernstein's time and advice. In contrast, over time, Attorney Bernstein never visited Mr. Trammell. Mr. Trammell eventually sent a complaint that was sustained, a bar complaint. It was a sustained complaint, in which Attorney Bernstein was forced by decree to present himself as a remedy to Mr. Trammell's complaint. So he come out there to the jailhouse and he told him, he's like, I'm gonna opt out of your case. Attorney Rupert, your address is the exact same address as Attorney Bernstein. So the judge, you're gonna hear it in there, they give him a new lawyer. Bernstein is fired, right? But he keeps appearing for his partner, Rupert. Anyway, Attorney Rupert, your address is the same exact as Attorney Bernstein. Would this be a conflict of interest? It is also Mr. Trammell's question to ask if at the viewing of the court's video you will be willing and able, by virtue of the facts, to initiate the process of recusing Judge GROEB. When will you be able to address probable cause issues? ? In the video, the state establishes the fact that at over 1 year and counting are still trying to establish the case against Mr. Trammell. In other words, they arrested him on a warrant issued by the state. Never finished his case. You're going to see that in these videos when they come up. Some points of interest for Mr. Trammell are view all discovery, challenge probable cause, and exploit the speedy trial process, or release on own recognizance. These are Mr. Trammell's requirements that he demands be fulfilled. Only one attorney has done anything and that is a bond modification hearing, as an audit of the docket and a record request for billable hours will reflect these facts. I am shadowing this case and advocating for Mr. Trammell. You need not respond, as I want no contact with you. This is the link to Mr. Trammell's court recording previously cited. And I leave links whenever I get the videos so they can't dispute it. This is a email on September 12th. Judge GROEB, I was last in court on August 15th. I had not been in court in over a year. Upon my appearance, I had dialogue with Your Honor. The right to a speedy trial was the topic of my discussion. My attorney Bernstein, who I made many attempts to contact and had someone go to his office and put me on the phone with him, and then I filed a deserving bar complaint, which was then followed by an immediate attorney Bernstein's first and last encounter, which was a 5-minute jailhouse visit because the bar complaint was sustained, I believe. Things were said by both Your Honor and Attorney Bernstein. These conclusive accusations by both were false in all aspects. The fact being, firstly, Judge Davis mismanaged this case in its entirety. Anyone and everyone concerned knew there was a co-defendant in a State Attorney Office 8's case. So from the start, I was assigned improper counsel, which was deemed a conflict of interest. These are the facts of the Public Defender's Office 8 Mueller involvement. From December to March, after formulating a complaint, I received 20 days in the box, a departure gift from my asking questions at the Alachua County Office of Criminal Conflict, Region 1, Attorney Hunt. Times 20 days, solitary confinement, forfeiture of all privileges. She then removed herself from my case. There was no work completed there either. I also draw upon the April 11th docket entry reflecting that I wrote to court. Let it be known that I had not physically or by remote appearance been to the courtroom after my preliminary detention 2024. At some time, Attorney Antoine appointed as counsel too. No work performed. Having still not appeared in court, but Attorney Antoine stated, Judge Davis does not wish to see me unless I am pleading guilty. This is either truth or coercion by Antoine. Bernstein works in the same office as Rupert, who is now my attorney. If Bernstein conflicted out, how is his partner going to represent me with an unbiased approach? That decision was made by you in your court. The dialogue of the last case management, August 15, 2025, the first time I went to court since July 2024. Your Honor spoke of his indifference with me. How that mordaciously was informed. Being delivered to me, coming from the confines of jail, only being seen a very few introductory consultation times by all these do-nothing attorneys that were allowed by first Judge Davis and now Judge GROEB to do more of nothing. Case management after deliberate delaying with case management granted by the court. You, Judge GROEB, expanded on the bare fact that speedy trial is not in my best interest, and you opined on the misgivings of such to include quoting your grandfather and your 15 years of experience that invoking a speedy trial gets a defendant an abnormally longer than normal sentence, topped off with cautioning that I would get more than I wanted and that it never works out with a speedy trial. There is a link to this video capturing what was said my first time in court in over a year. That video was purchased from the court reporting and published to YouTube for posterity. Here's the link. I always send them the link. I believe that my rights have been violated by the court and that the Judge GROEB knows the remedy for this. I pray that you, Judge GROEB, acknowledge the fact that Judge Davis allowed this mismanagement and to include that the defense that Judge Davis appointed was ineffective, which has harmed my case, and that gives the state more advantage than should be afforded. It may not be exactly the way I call it with my words, as I am just a layperson in detention for crimes I didn't commit, in which probable cause is lacking, and at the best the state would not be able to establish guilt, even if merely statutory evidence would be allowed by my absent defense. This case was made/developed before I was arrested, and the court allowed the defense to do no work, period, except delay, delay, and delay. What was the purpose to allow the state or the defense to do that? Question mark. Not one thing was done to bolster my innocence for more than 1 year. No motions, no depositions, no complete discovery, just nothing. Now Judge GROEB is assigned these cases, and you fault me for trying to get my attorneys, 5 of them now, and counting, to do any work in my defense. Instead, you release your bias upon me with absolutely no comprehension or acknowledgement, and refusing to see the clearly evident true truth I was conveying. I believe that my accusations must be answered, and that these improprieties must be reported, and legal counsel should work to get my charges dismissed on these facts with prejudice for the gross violation to my right for a speedy trial, and to condemn Judge Davis in summary for violation of oath of office. Judge GROEB, I believe after encountering you like Judge Davis, you undermine by impartiality and unfairness the confidence of the public's trust in the 8th Judicial. The fact that the court's business with me would take another period of approximately 6 more months, which is further neglect of the court's duties and his right to a speedy trial. And this was written for detainee J.C. Trammell. All right, there's on September 22nd, in a jailhouse phone call, Mr. Trammell requested I email you and that I ask you if he has an attorney representing him, and who is that, or who that is. Please don't respond to me. I am just conveying the request. Contact Mr. Trammell. And Michael Ruber says, but who is this? And then I emailed him again. This is 10/20, October 29th, yesterday. An inmate at the Alachua County Jail has asked me via a phone call to contact you by email. His request is for you to schedule a consult with him, as Mr. Trammell is to appear in court November 24th. I mean, this shit's crazy, bro. These people, they don't have no care in the world. They just left a man sitting in there. Now he has a co-defendant that already pled guilty, and his sentence is going to be over soon. I'm just saying, this is madness. But the co-defendant isn't really connected with him. The co-defendant was the thief. The co-defendant got all the charges. Now you're going to see all this in these videos as soon as I shut my mouth. But I just wanted you to see the lengths that we go to, any length to try and convey these matters to the court. The court don't want to hear them. They just want to leave the man in jail until he pleads out. That's the actual factual reality of the situation. And I'm going to shut my face. Thanks for listening. I appreciate y'all watching. It really helps when y'all watch these videos because it shows people care. Thank you for your time and effort. Blue Steel out.
From the case management docket, in custody, J.C. Trammell, 24 CF 1913A, 24 CF 2245A, 24 CF 2247A, and 24 CF 2248A. Celeste Ramirez for the state, Mr. Bernstein for the defense.
What was the defendant's name again?
Last name Trammell.
No, right? Mr. Bernstein?
Your Honor, I don't know if the court has been informed, but we filed with your office a motion to withdraw on these 4 cases based on the most recent letter that my client has written to the court, or put into the court's file. I'm not sure whether it was written directed at the court, but I am the third appointed counsel for this individual. He has expressed the request for filing speedy trial demands, motions relating to improper carrying on without regards to the speedy trial. I've tried to inform him my opinions on that, and I think previous counsel has also engaged in that type of advice. I believe that we have to have a good faith belief that there is a violation of the speedy trial provision and have appropriate investigation to show that, and represent to the court that we are prepared to go to trial within that time. And that's not the case. We've not had good conversations, but we've had conversations. I believe he's misrepresented some things in his last missive to the court that's in the court file. He indicated he filed a bar complaint. At this point, I don't feel that we're going to be able to work together. I think there's irreconcilable differences. I'm not going to budge on my willingness to proceed. He doesn't appear to be willing to budge on his demands for what needs to be done. And the case has been at a stagnant, locked position. So that's the basis for my filing the motion.
You say you're his third lawyer? You're
Yes,
the
third
lawyer?
appointed counsel.
Okay.
There was the public defender and regional counsel, and I think there have been one conflict.
Well, I can tell you this, Mr. Trammell.
Yes, sir.
I don't have any patience with somebody who keeps firing their lawyers, okay? So if you think for some reason in your mind that every time you pull this kind of stunt that I'm gonna appoint a new lawyer for you, you're wrong about that. You keep doing this and you might be representing yourself.
Your Honor, may I say something?
Sure. You
Your
want
Honor,
to?
I've never fired any of my attorneys. They all withdrew off my case. When I filed my complaints concerning them not doing, as I request for a speedy trial, I would like to also read this to you to update you on some of the things that's been going on.
Let me just explain one thing to you before you read that. I've been doing this for a long time. I've seen a whole bunch of people standing right where you're standing in the past, over the past 15 years, making crazy demands for a speedy trial. And it's the old adage, my grandfather used to use, be careful what you ask for, because you just might get it. And they got their speedy trials, and then they ended up going to prison for 30 or 40 or 50 years. So there is a price to be paid for recklessly demanding a speedy trial. Your lawyers are deprived of the right to depose witnesses, to investigate the case fully. So you may think you're doing yourself a favor by demanding speedy trial, but you're really not. At least I've never seen one turn out well in 15 years that I've been sitting here. So you really need to think about what you're doing here.
Yes, sir.
You're really not looking out for your own best interests, in my view.
May I continue, sir?
Sure.
All right. Your Honor, Judge GROEB, I have been in the Alachua County Jail for 1 year and 27 days as of this date, August the 7th, 2025. And not once have I been able to appear in Judge William E. Davis' courtroom to address the letters and emails that I have sent to the court. I have been kept silent due to my court appearance being waived without my knowledge and also without my written consent. I have been appointed 3 attorneys, in which 2 of them, Ms. Deborah Hunt and also Mr. Yevans Pierre Atone, both have told me that Judge William E. Davis will not allow me to appear in his courtroom unless I am willing to accept the state plea or go to trial. My court date has been continuously being rescheduled for case management after I have been requesting for a speedy trial and also a demand for a speedy trial. Both attorneys have withdrew themselves with no results other than a delay and also a violation of my constitutional rights in which I have. Your Honor, I've been in this county jail for, like I said, 1 year and 27 days. I've only requested a demand for a speedy trial because I'm innocent of what they're charging me with. I've also been accused of, I also had a sworn complaint for a child, and it's been used against me from the state attorneys that I had another charge that they was going to put on me, which they had no jurisdiction to even use in my bond reduction. Therefore, that's why my bond reduction was denied. And every time I ask my attorney to put in for a demand for a speedy trial, I get nothing. I also asked for a motion for an evidentiary preliminary hearing, which never get done. So I'm not asking for. I had never tried to fire my attorney. I just made a Florida bar complaint because none of the motions that I asked for was put in. So therefore, when I asked for that, they just jumped off my case because they must be they wanted to delay. I've never fired one of my attorneys. I just was requesting for them to do something to defend my case. One, I have proof that I did not fire my attorney. She withdrew herself, and also I got sentenced. She falsely accused me of harassing her, and I went and did 20 days in the confinement, and it wasn't even for the harassment. It was for being not for not being in the right place, which that wasn't true.
Have you filed a bar complaint against Mr. Bernstein?
I have not seen this man but once, and that.
I'm just asking you a simple question.
Yes, sir. I filed a complaint that he was not communicating with me. He haven't came to see me since he's been assigned to my case. So I just wanted to talk to him.
I'm certainly going to grant your motion and to withdraw, Mr. Bernstein.
Thank you, Mayor.
So where does that leave us in terms of another lawyer? Ms. Ramirez?
I don't think you guys have anything to say about another lawyer.
No,
I'm just
Your
saying,
Honor.
where does that leave us now, since you know I'm going to let Mr. Bernstein withdraw?
Your Honor, the only thing I can add to this is for Mr. Tramel's benefit is that he previously, to resolve all of these cases, was given the opportunity to resolve with a downward departure that I'm not sure that this court would accept, but it was for 36 months, and he scores over 70 months in the Department of Corrections at the bottom of the guidelines on these cases. That was with the condition that we would also drop the sworn complaint that he alluded to as well. That was to his benefit. That wasn't something that was used against him. The state is still investigating that sworn complaint because that business is no longer in service, and so we are looking to speak to the former owner of the Lightning Pond to obtain surveillance.
So he's charged currently with 3 counts of grand theft, 1 count of dealing in stolen property.
Yes, Your Honor.
So he's looking at 30 years in prison potentially.
Yes, Your Honor.
All right. I have not seen your motion to withdraw yet, but I'm telling you, Mr. Bernstein, it's probably in a stack
Yes.
of papers in there. I will go find it and sign that for you.
Your Honor.
All right. So I think we probably need to appoint. Were you appointed like the old conflict list? Or
It's
whatever
similar to
we're
that,
calling
yes,
these
sir.
days?
There's a very limited list right now. I think there's about 3 names on it.
Okay.
And then after that, the judges go and look and see who they can impose upon to accept an appointment, a special appointment.
Like the old days, if you were in the wrong place at the wrong time in the courtroom, you got appointed.
Yes, sir.
Your Honor, may I please say one more thing?
Sure, sure.
Your Honor, all these continuances, case managements, and withdrawing off my case is doing nothing but delaying my case and harming it even worse.
Well,
And also the state is saying that the Home Depot and the sworn complaint is from a lotchway from the Home Depot, which is not, the establishment is not closed down.
You understand.
These are not true facts that the
You
state of.
understand the contradiction here, right? You filed a grievance against Mr. Bernstein.
I didn't file a grievance, I filed a complaint.
Hang on.
Oh, sorry,
Don't
sorry.
talk while I'm talking.
Yes, sir, sorry.
You filed a grievance with the bar and Mr. Bernstein. Now he's required ethically to withdraw from your case. Now you're complaining to me that your case is going to be dragged out even longer because Mr. Bernstein has to withdraw. That's a situation of your own making, as I see it, okay? You may disagree with that, but it doesn't really matter what you think, because I'm the one sitting here in the black robe, okay? So don't complain to me about sitting in jail for a year when a lot of this is your own fault for not cooperating with your lawyers, not doing what they, arguing with them, trying to make them do things that they know are not in your best interest. So, again, your pleas are falling on deaf ears here, okay? I'm gonna, do we have the appointment list for that, Madam Clerk?
Once the order is filed, Your Honor, then we do have someone that will go through the list. of
Rotation.
appointments.
All right. So I'm gonna go ahead and relieve Mr. Bernstein. We'll appoint a new lawyer. I'm gonna set the case on September 15th for another case management.
Thank you, Your Honor.
All right, thank you.
Case management docket in custody, J.C. Trammell, 24 CF 1913A, 24 CF 2245A, 24 CF 2247A, and 24 CF 2248A. Celeste Ramirez for the state, Mr. Bernstein covering for Mr. Rupert for the defense. J.C. Trammell.
Mr. Trammell, good afternoon, sir.
You know, when I agreed with to help Mr. Rupert and appear for him, I didn't realize this was one of his cases. As the court knows, I withdraw from Mr. Trammell's case. My understanding is the state does not oppose a 30-month continuance to another case management.
No objection to a 30-day continuance, Your Honor.
All right, let's do that then. Not to put you in a bind here, Mr. Bernstein, why don't we put it on October 20th again, at 2 o'clock?
Your Honor,
Mr. Rupert.
may I say something?
Yes, sir.
Have you received my emails? Have you received any of my letters?
I don't take emails from prisoners, okay? If you file
not-
something in the court file, the clerks will forward it to me, but I don't, if you were to email me something and I saw that you were a defendant on my docket, I would delete it. I would not.
Okay, that's understandable. Not for me though.
Yeah,
But may I read something to you?
sure, if you want to.
Yes, sir. Your Honorable Judge GROEB, my bad, I'm sorry. As I stand before you this morning in the presence of the Most High God, I would like my words to be reflected on the records. In this letter added to my case file, I have been an inmate at the Alachua County Jail for 14 months and 4 days on charges that someone else has already been sentenced on. I have asked my appointed counsel to demand a speedy trial. Since I have been here to prove my innocence, all which seems to have fallen on deaf ears, and clearly a violation of my constitutional rights. The courts have appointed me new counsel several times due to this. Yet upon renewing new counsel, after counsel, none have filed the motion demanding my speedy trial. My new counsel, Mr. Michael T. Rupert, who replaced Mr. Stephen N. Bernstein, is also a conflict, which has already been stated. I discovered after doing my due diligence, they share the same address according to their Florida Bar membership profile. Let the records reflect this, and my oral motion be accepted demanding a speedy trial. I have sent a copy of this letter to the state attorney, the clerk of court, and Mr. Michael T. Rupert. So all parties are aware of my demands. I pray that my demands be answered and a speedy trial is granted. So may it be. Also, let the records reflect that I have asked that a motion to compel discovery be filed on all 4 cases and granted by the judge so that I can create an effective defense for my case moving forward towards a speedy trial. If no motion has been filed or a motion demanding a speedy trial is granted in the amount of days allowed, I will motion to dismiss my case with prejudice on my next court date. All of this is submitted to the courts and to be added to my case and records, that in the event any injustice takes place, my attempt to forego them be displayed. So may it be.
All right. I think I understand sort of what you're asking me to do here. But let me explain a couple things. I'm assuming probably all of your former lawyers have explained to you as well. One of the reasons why your case has been around so long, and I've looked at the docket lines on it, is because your lawyers keep withdrawing. And what I've heard twice now is that the primary reason they withdrew is because you're forcing them to demand a speedy trial.
Not forcing, sir.
Well, you're asking them to do that.
Yes.
they're refusing to do it, and then that's creating what's called an irreconcilable conflict between you and your lawyer. Your lawyer moves to withdraw, then I have to appoint another lawyer. The case drags on 2 or 3 more months while that's happening. So I guess what I'm saying to you here, sir, is this problem in many respects is of your own making, okay? When you're forcing your lawyers to repeatedly withdraw, filing bar complaints against them, threatening to do things to them, you're delaying your case on your own by doing that. Number 2, I want to tell you, the 16 years that I've been doing this, sitting in this bench, I have never seen a demand for speedy trial work out well for a defendant, okay? If you demand speedy trial and your lawyers have not done discovery, have not interviewed the witnesses, you're putting yourself at a severe disadvantage. Your chances of being acquitted are going to go down dramatically because the lawyers that are in here representing you are not allowed to be properly prepared by engaging in discovery.
And I'm aware of all that, sir.
Okay.
Thank you.
So I guess what I'm saying to you is be careful what you ask for here, because eventually we're going to run out of new lawyers to appoint for you. And when that happens, I may just grant your motion for a speedy trial, and you'll be representing yourself in front of the jury.
Well, Your Honor, this,
I don't know if you want that to happen. I don't want that to happen.
Your Honor, I've been asking for this since I've been here.
Yeah, but I'm just telling you where this is probably going.
To stop, to,
So I want you to meet with Mr. Rupert and talk to him. The other part of the law is that you can demand, you can file any pleadings you want to, you can demand anything you want, but as long as you're represented by a lawyer, those demands you're making are a nullity. The only way they have any force and effect, and I have to follow them, is if you're representing yourself.
so Miss,
So your speedy trial demand that you put in this letter is completely ineffectual because you're represented by a lawyer. Only your lawyer, your counsel of record, can file that demand. Okay?
yes, sir. Mr. Rupert is trying to withdraw himself off my case
Okay.
because he's no longer can represent me due to the conflict that me and Stephen Bernstein have.
Well,
And
then
also,
I guess if he files that, then I'll review that and see if I can sign that when he files it.
Also, there's no reason for these attorneys to be withdrawn off the case, other than them creating a delay for the state. Also, I would assume that you signed off on this. You should have been aware that Mr. Rupert and Mr. Bernstein are associated with each other. Also, in this motion that you signed off on, it has a case in here that I'm not even booked in on. It's the 0124 CF-2249 case. This is also on here, and I'm not charged with this. I'm trying to figure out why it's on this motion
I'm
that
not
you
sure.
signed off for.
I did not prepare the motion, so it might be a typographical error. They might have left an old case number. I don't know the answer to that.
Okay, well,
But
I wish that the courts would move it, if they can, because it's showing that it's open. The case is open on the records,
I'm
on
gonna
the
let you.
court's computer.
I'm going to let you meet with Mr. Rupert, okay? And if it turns out that he withdraws, we'll go from there. But he so far has not withdrawn because I have not signed an order to that effect.
Yes, sir.
Okay? All right. Let's, I'm sorry, Mr. Bernstein, what did you want to do with that for Mr. Rupert? So you case managed it for 10/20, I think?
Yes.
Yes, Your
Still
Honor.
work, all right. That is correct. Very good.